The Trump administration finally responded to the Supreme Court's Second Amendment Preservation Act challenge that's currently in front of them, and they continue to argue that this state law is invalid and that the Supreme Court should deny review. However, this case has now changed because of some political shakeup that just happened. So let's break down what is happening in this critical challenge. Now, before we jump into this video, if you want to support the channel, of course, the best way to do that is subscribing to the channel. Also, double check to make sure YouTube is not unsubscribed you because they love to do that. And then you can also check out my website, armscholar.com. Over there, we have a lot of things available for you guys, including the free legal guide that you can sign up for. I will leave a link to that down below. All you have to do is put in your email, and we email you over a free PDF. In this video, we're going to be talking about a huge Second Amendment Preservation Act case that's currently back in front of the Supreme Court. This is a case dealing with a state's SAPA law, a Second Amendment Preservation Act that was put in place in the state of Missouri. We've discussed this case before because recently the Supreme Court issued an 8-1 order denying a stay which would have protected Missouri's SAPA law. This case is now back in front of the Supreme Court, and the Supreme Court will now consider whether they're going to grant review to this issue in September. However, there have been some political shakeups caused by the Trump administration that is potentially going to now impact this case. Now, you might remember that in this case, the Trump administration continued to argue that the SAPA law is invalid in some of its applications and that the Supreme Court should deny review to this case. But what ended up happening is at the same time, they argued to the Supreme Court that if this was sent back down to the lower court, eventually the Trump DOJ would release some of the judgment that the prior Biden administration got from the lower court. Missouri responded by pointing out that the concession made by the Trump DOJ is exactly why the Supreme Court should grant review to this case after their September 29th conference. But what is interesting in this case is now it potentially is going to be impacted by some of the political shakeups. The Missouri Attorney General Andrew Bailey was just elected by the Trump administration to serve as co-deputy director of the FBI. And this week, Andrew announced that he's going to be resigning from his position as Missouri's AG on September 8th, and he's going to go serve as that co-deputy director of the FBI. That means that before this case gets to conference in the Supreme Court, the Missouri AG will actually resign, and the case may actually stall out or get moved because of those political changes. Now, this lawsuit revolves around the 2021 Second Amendment Preservation Act that was put in place in the state of Missouri. The law sets the state's interpretation of the Second Amendment and sets restrictions on the support and funding that the state will provide to federal agencies in their attempts to enforce what the state believes are violations of the Second Amendment. The law prohibits Missouri's officers, agents, and government officials from helping federal agents who are attempting to enforce those inconsistent laws. The law also created a civil remedy where any resident of the state of Missouri could sue a Missouri official if that official helped to enforce inconsistent federal laws. So the law aimed to give the true enforcement powers to the residents of Missouri instead of actually having the power in the state or any of its officers or agents. Now, in this Missouri case, the district court originally on review ruled in favor of the then Biden administration, striking down the SAPA law in its entirety. Now, in response, after that, the state of Missouri appealed to the 8th Circuit. They wanted a stay from the 8th Circuit. They wanted a temporary halt on that judgment. It was denied by the 8th Circuit, and then this went to the Supreme Court on an emergency basis. However, on review of that emergency application, the Supreme Court issued an 8-1 order denying that stay. Only Justice Thomas was in favor of granting that emergency stay, which would have halted what the lower court said, essentially striking down the entire SAPA law as it currently stands. Now, after that denial, the case was sent back down to the 8th Circuit, who then held expedited oral arguments in this case. And the 8th Circuit ultimately ruled in favor of the federal government, essentially the Biden administration at that time, striking down the SAPA law once again. But now Missouri has filed a writ of cert to the Supreme Court. One of the big things that Missouri points out in this petition is that the 8th Circuit essentially said that the structure and potential operation of this law is valid, but they ultimately struck down this law because of its underlying Second Amendment purpose. Missouri argues that the 8th Circuit went against clear precedent and found that state officials could still be sued because the court there believed that a state played some sort of role in enforcement by simply complying with the law. And essentially, they found that compliance was the non-action or non-enforcement of these federal laws. And so they found that non-action or non-enforcement was actual action or enforcement. This law, like I mentioned, was originally opposed by the Biden administration, but now the Trump administration clearly has control of the case. And initially, they stalled out their response for multiple months, but recently they did file their answer. And in that response, the Trump administration continues to argue that the SAPA law is invalid and that the lower court actually got the decision correct. However, at the same time, they also argue in that same brief that the Supreme Court should deny review to this case, and when they do and it gets back in the hands of the district court, they are willing to actually concede some of the judgment that was granted by the lower court. They argue in that response that having reevaluated this case, the United States has concerns about whether the judgment below extends too far and enjoins applications of the act that do constitute mere non-enforcement of the federal law protected under the anti-commandeering doctrine. And those concerns are exacerbated by the uncertainty in this pre-enforcement posture about how certain provisions of the act will be applied and about whether the provisions of which the Eighth Circuit focused are indeed inseparable from the rest of the act. They state that given those concerns, the United States has decided that it would acquiesce in narrowing the scope of the judgment under Federal Rule of Civil Procedure 60B when the district court gains control and jurisdiction of this case. So after stalling the case for a few months, the Trump DOJ finally responded, and they responded by continuing to argue that some aspects of the SAPA law are invalid and that the Supreme Court should deny review to this case. However, at the same time, they said that if the Supreme Court kicks this case, this administration believes that the pre-enforcement judgment that was issued by the lower court maybe went too far, and they're willing to let go of some of that judgment on their own. Now, in response, Missouri argues that even if the administration drops some of the judgment in the lower court at the district court level, the primary ruling that was issued by the Eighth Circuit will still remain as precedent and ultimately harm the case down the road when it gets back to the Eighth Circuit. Therefore, Missouri argues that the Supreme Court should not punt this case, they should not avoid this issue or deny review, but instead they should take review, rule on this case right now, and reverse what the Eighth Circuit said because it's wrong. This challenge is currently scheduled for Supreme Court conference on September 29th, but I have a feeling that this conference is likely going to be moved, especially in light of the Missouri Attorney General Andrew Bailey and him, putting out a notice that he is going to be resigning and joining the FBI, in the near future. It's unfortunate to see Andrew actually leave the Missouri, Attorney General's office because he's been critical in a variety of pro-2A challenges like this one, and he's even been critical in filing other lawsuits like censorship lawsuits against social media companies. But hopefully his move does not doom this case, and I would, think he's going to do amazing things while he's with the FBI, and hopefully, actually, that puts him in a short list if anything ever changes with the current Attorney General, Pam Bondi. If she ends up getting removed, I would love to see Andrew Bailey actually serve as the U.S. Attorney General. I will state, of course, and probably disclose to you guys that I have bias because I know Andrew, personally. I've spent time with him. I know his team as well. We talk quite often. So I have bias, and I believe that Andrew Bailey would be a great U.S. Attorney General. I think he would, do amazing things as, at the head of that. I think, he has a good grasp of a lot of 2A cases as well. He really understands the Second Amendment, cause, and he's appeared to a lot of conventions. He's spoken at a lot of conventions that I've been at, the GOA Goals Conference and GunCon and all of those things. So he's very in tune with the Second Amendment cause, and I think he would do a great job as the head of that office. But right now, he's going to serve as a co-deputy director of the FBI. However, with him now leaving Missouri, that's going to open the door for potentially this Missouri SAPA case to stall out for a bit. So we're going to keep our eyes on what happens in this critical SAPA case. But it appears the current Trump administration strategy is to avoid Supreme Court review and limit the decision down below in the lower court. Like I mentioned, currently this case is set for conference on September 29th, but there is the option now for the Supreme Court to punt the case, move the conference, or potentially, just hold it for a while because of the Attorney General resignation that's happening. So we're going to have to keep our eyes on this case to see what happens and maybe how it's impacted by that in the future. So as we get more information, as this develops more, I will let you guys know. If you like this video and you like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, like I mentioned, you can check out my website, armscholar.com. Over there, we have channel merch and other things for you guys. And again, we also have the free legal guide over there. I will link that down below in the details section and in the pinned comment. Again, all you have to do is put in your email, and then we email you over that free PDF. But as always, thank you guys so much for all of your support. And never forget, this nation was built by Armed Scholars, and this nation will be maintained by Armed Scholars.